More bad news for Judge Glenville in his YSL and Young Thug trial. Now, if you've been watching this YSL trial, then you know that about last week, Young Thug attorney filed to have a mistrial after learning about a secret meeting that Judge Glenville and the prosecutors had with a witness called YSL Woody.
Court handed Mr. Copeland.
Tell me how you
perjury.
got the information.
Listen, whatever you want to do.
Tell me how you got the information, then we can go ahead and go forward.
I'm not going to say that. What I'm going to say is this. I was told, and I hope this concerns the court.
It concerns me that you have proprietary information.
Why is it
or
proprietary?
Information that you should not be having that was ex parte.
Why?
With a party.
Why?
State of Georgia.
How about the witness? How about Mr. Copeland, who supposedly announced he's not testifying and he'll sit for 2 years, and then supposedly this honorable court, or excuse me, let me rephrase that. This court supposedly said, I can hold you until the end of this trial. Ms. Hilton supposedly said, actually, all of the defendants and then all 26 people are disposed of. If that's true, what this is coercion, witness intimidation, ex parte communications that we have a constitutional right to be present for.
Just a quick wrap up. After this, the judge proceeded to decline the request for a mistrial, but instead he sentenced Brian Steele to 20 days in jail for exposing the fact that the judge and the prosecutor had a secret meeting with a witness called YSL Woody behind the defense's back. After that took place, the appellate court told the judge, no, you're corrupt. We have overturned your jail sentence of Brian Steele. He's not going to jail. Stop it. All right, then after that, the co-defendant, Yak Gotti, his attorney, filed a motion to recuse the judge from the case. The judge declined the request, and he refused to allow a immediate review by an appellate court. So now we're back in court this week, and Brian Steele has upgraded his motion from a mistrial. So now he wants to recuse the judge as well. So he has filed a motion to recuse the judge, and this is what we're dealing with in court right now.
This morning, I have two motions to recuse, one filed by defendant Jeffrey Williams that was filed yesterday. And
yo, I'm gonna say, imagine being a judge on this case, yo. Like truly imagine like being a judge and having to think to yourself, bro, yo, I'm really a F up. Like, I really fumbled this case so bad, bro, that you have multiple defense attorneys, bro, filing to have me kicked off the case. Like, that's how bad of a F up I am, bro.
Hand it to the court at the end of the business day. Another one has been filed under the same indictment, just indictment 22 SC 183572. And I want to say that motion to recuse has been filed on behalf of Miss Kayla Bumpus. Can I get the lawyers for, or the principal lawyer for that particular case to identify themselves for purpose of the record?
Yo, so Kayla Bumpus, if you guys don't know, she was the attorney that was in the chambers with YSL Woody, the prosecutor, and the judge. She was the one who witnessed the prosecutor and the judge try to coerce and intimidate YSL Woody, right? However, she was just filling in for YSL Woody's main judge. So afterwards, she alerted the defense attorneys for Young Thug, Brian Steele, and said, yo, we just had this secret meeting and they was trying to intimidate like YSL Woody, right? So after Brian Steele brought it to the forefront, Brian Steele refused to snitch. Brian Steele got held in contempt. The judge then, after Bumpus said, yo, I'm taking myself off the case because I'm not even his main attorney anyway, and his main attorney is back, so I'm taking myself off the case. She took herself off the case, and YSL Woody fired her. This corrupt judge brought her back to court and ordered her to show up like a week later for a contempt hearing to sentence her to jail for allegedly telling Brian Steele about the secret meeting. That's how corrupt this judge is, bro. Like, bro, he's out of control. Like, he's absolutely out of control. Right, so now Bumpus is saying, bro, like, this is like super unethical. So now her attorneys is filing to get him recused from the case.
Judge, good morning. Gabe Banks.
Good morning, Mr. Banks.
Her legal team is also here. Mr. Collins, Mr. Obey, Mr. Mormon, and Mr. Winchester.
All right, good morning, counsels. Okay, as your...
Yo, what? Oh, they came squad deep for this. Oh, they came squad deep. Yo, five attorneys came for five attorneys came to represent Ms. Bumpus because the attorneys like in that county, bro, are sticking together. I remember when Brian Steele got sentenced, you had like 20 attorneys who showed up in the courtroom, like to support Brian Steele. So now you got 5 attorneys showing up to represent Bumpus because they feel like this judge is stepping out of turn, bro, right? And he's bullying attorneys in the courtroom.
Bare assertions and legal conclusions which aren't sufficient for the court to grant your motion at this point in time and refer it to another judge for it to be heard.
Yeah, this is like, so, and here's why I say, like the legal system is just BS, right? So we all know this trial is gonna be a mistrial. We know this judge is too stubborn to grant a mistrial right now or recuse himself. But we know, bro, like after a verdict comes back, bro, and the appeal happened, bro, it's gonna be overturned. A mistrial is gonna be granted, bro. There's just too many mistakes that took place in this case, right? Now, this judge is a stubborn judge, right? So he has automatically squashed or quashed any type of motion to take him off the case, right? Because again, why would you? But here's the thing, and here's the one thing I don't like about this ruling, right? So the judge decides whether or not he recuses himself, right? But the judge is also the one who decides if there's an immediate review for an appellate court. Meaning, if a judge says, yo, I'm not taking myself off this case, I feel like it should automatically go to an appellate court and have them review it. But it's the judge's decision. He's the one who decides if trials get paused or an appellate court to decide whether or not he gets off the case or not, right? Which is why, like, the legal system is just so dumb, because why even have the motion out there to recuse a judge if the judge can just decline it and then refuse to pause trial to allow an appellate court to recuse him? I don't know, man. It's just dumb.
So I'm going to deny the motion at this point in time. I invite you all to look
Of course.
at Baptiste versus the state. Just because adverse rulings have been made, doesn't mean that the court stops the trial. So I'm going to make that. I'll reduce both of the motions to recuse to an order, and I will file that so you can take whatever steps you need to necessarily after that. But I don't get into anything about the affidavit itself, argument on that. I just have to read it. Those are the only 3 things I do. And then if I find it to be not sufficient on its face, I go for it. I just make the ruling at that point in time, let you all take it up. No, I won't grant a motion for a certificate for immediate review.
How is this even okay, bro?
And
like, how can a judge do this
at this point in time? Anything else, Mr. Banks?
If I could just briefly be heard, Judge.
Sure.
Please. And I'm not trying to
chew him a new butthole.
And we'll proceed as we see fit. I do take issue with the court's characterization about the legal insufficiency of the affidavits.
Well, that's why when it was reviewed on appeal,
Sure.
it can certainly be. I mean, the court.
Yo, this judge knows he's so wrong, bro. Like, he knows, bro, like he's so wrong, bro, that he wouldn't even allow them to present the argument in court for why they do have sufficient grounds to take him off the case, right? Right, like, it's like, you'll notice, like, whenever they try to make a point, bro, like, he cussed them off, saying, no, hey, send for appellate court. I don't want to hear it. Bro, what do you mean you want to hear it? Bro, like, it's your job to like, decide based on everything, right? Based on the testimony, based on them documents. Why are you now cutting me off when I'm trying to prove to you, and plead my case as to why we believe we have sufficient grounds?
Or the appellate court will review my ruling for abuse of discretion.
Certainly understand that, Judge. And in stating that, Judge, I would just say that one of the issues that is raised in our affidavit, because our motion to recuse is to recuse you from the contempt proceeding, not the underlying criminal case in which Your Honor is presiding. And so we really don't have an issue or standing to even challenge that. And so to the extent that there is a contempt proceeding that is set for the 25th, Your Honor, you are a witness to that proceeding. And so because you were a witness.
I don't believe you. I'm not going to get into any argument, but I can't. So
Facts, right? So this is Bumpus' attorney. Bumpus is the attorney that was in the secret meeting with the prosecutor and the judge. She's the whistleblower. They're saying, yo, judge, like, she's the whistle, like, she whistle blew on you. We don't think it's fair that you should be able to preside over sending her to jail for whistleblowing on you. Can you take yourself off that and let another judge decide whether or not, like, she broke any type of rules and laws, or or like whether or not she like disgraced the court? But if you are about to sentence her or like preside or rule over her contempt hearing, when the contempt is her whistleblowing against you, how is that fair? And I completely understand what they're saying.
that's your assertion at this point in time, and like I said, when that is taken up, I'll consider. I also remember I still need to rule on the issue of the motion to quash. So I may, depending upon what I decide to do at that point in time, other things may be ripe. Okay.
Do you want to hear about the motion to quash, or you want to take
No,
that
no,
discussion?
not yet, sir. I'm going to take up the motion to quash after I finish. We finish the direct of the current witness.
Okay.
And to other issues that have been raised, as I've told some of the other lawyers here, there is a transcript of what occurred in the ex parte matter. I will, in fact, I'll authorize defense counsel. I'll do a privilege review and see what needs to be disclosed in terms of impeachment and or Brady.
Well, but why do you need to review it though? Why not just give them, again, if the meeting was not supposed to happen, why not just tell them exactly what was said in the meeting? Because they were supposed to be present in the meeting, right? And if they were supposed to be present, then they have every right to see exactly what was said in that meeting.
And for that, and I will do that. And then so if that pertained, or if that issue affects you, then certainly that may be something that at the appropriate time you'll be able to have a look at.
Well, I appreciate the court's time. We would certainly rely upon our brief and our motion, and that's a part of the record.
Okay. All right. But
man, bro, where Brian Steele at, man?
The court will reach out to you on two things.
Yo, he too friendly, bro. Yo, bro, where Brian Steele at, bro? Yes, sir.
I have read
Here Daddy Steele at, man. Come on.
State. I've read all the cases that I believe are applicable. I'm, best I can. But
yo, like, this is such like a strange interaction between the two, because you try to put me in jail for 20 days. The appellate court saved me. Now I'm coming to court every day with a vendetta against you. And you probably hate my guts too, since like I'm the one who sort of like whistle blew and like exposed you in court. So now like these two are like extremely hostile towards each other, but like they literally cannot be hostile, because Brian Steele knows that he has to like be respectful to this judge if young thug is gonna stand a chance in court. And this judge knows that he can't be like super biased against Brian Steele if he wants to like have a job after this.
specifically, if the court would reconsider, and if nothing else, the Honorable Keith Adams and my joint affidavit in paragraph 12, we assert not a bare assertion or a legal conclusion, but we make facts that we specifically adopt from the Honorable Attorney Winchester, Collins, Banks, Nove, and Mormon's motion, where a person that they represent was in a meeting ex parte with the court and others, and the prosecutor and a witness, and specifically they wrote in a pleading and under Parrish, which is P-A-R-R-I-S-H versus State, which is 362 Georgia Appeal, 392 Division 1, 2022.
Oh, he comments spanking. Oh, he's spanking shit today, bro. Man, come on.
Pleading on behalf of the client becomes a statement of the client. And they said that this court got involved with speaking with Mr. Copeland and assisted in Mr. Copeland testifying against Mr. Williams. So I've added this court to the witness list. I plan on calling the court as a witness in the trial. I added lawyers Hilton and Love from the district attorney's office to the witness list.
Oh. They they spitting. Yo. So if you don't know why this is smart, right? If he's able to successfully call the prosecutors as a witness, because again, misconduct was done, the prosecutor and the judge illegally had a meeting with a witness, and they intimidated and coerced that witness to take the stand and testify against Young Thug after that witness said, "I plead the fifth and I don't want to testify." If he's successful in classifying the prosecutors as a witness and the judge as a witness, then the judge has to recuse himself. The prosecutors have to be replaced. And that's what he's saying. Yo, I'm not talking about, bruh, I'm addressing the facts here. You was in that meeting, she was in that meeting, he was in that meeting, Woody was in that meeting, and Woody's lawyer was in that meeting. Woody and his lawyer is given facts as to what was said in that meeting. I'm saying based on those facts, you gotta go. I don't see how Judge Glenville is trying to circumvent this, bro. You got caught with your pants down, homie. Give it up, man.
And when I cross-examine Mr. Copeland, when that day comes, I'm going to ask him about how much pressure, if any, the court put on him. And you're going to be the one instructing the jury. And I just can't imagine how that's fair to Mr. Williams.
Yo, bro, this is why we call him Daddy Steele, bro. Bro, Daddy's still been spanking shit. Bro, Daddy's still been spanking this, man. Bro, do you hear this, man? He Teflon.
How much pressure, if any, the court put on him. And you're going to be the one instructing the jury. And I just can't imagine how that's fair to Mr. Williams. So I just ask you.
It's literally checkmate. It's literally checkmate. I'm going to be cross-examining YSL Woody, trying to get him disqualified or trying to get him to admit that the judge and the prosecutor put pressure on him to get him to testify. If you're going to be the one instructing the jury, as I cross-examine him to implicate you in something and you in the crime as well, how can you be overseeing this? Oh, nah. Hey, listen, bro. This judge got to get off this case, bro, or else a mistrial. It's that simple.
I'm not demanding anything in the joint affidavit from the Honorable Attorney Adams and myself, but if you would just look at just even paragraph 12, again, if you didn't consume it entirely, I don't believe that meets a legal conclusion or a bare assertion. I ask the court to recuse.
I've read your affidavit, Mr. Steele, and I've consumed everything on it, and that doesn't change my ruling at this point in time, respectfully.
I also, on the transcript, I'd like the recordings and the transcript, and I object to the court going through it and deleting, because to me, the way I understand it, there is zero privilege. So I don't understand
I'm not going to, Mr. Steele, I can't argue with you about anything such as I've made my ruling, okay?
Do you understand like how is this man not in a prison cell by now? What's wrong with you guys just handing over the transcripts and the recordings? And the recordings. Mind you, this judge just stated, yo, I'm gonna hand over the transcript after reviewing it for privilege and try to figure out what things need to be deleted. Nah, bruh. Why you delete, bro? If you don't got nothing to hide, why you deleting? Cause you know what y'all, bro. Cause you know, bro, y'all was on some fuck shit in that chambers, bruh.
Do you have some other basis to ask for the recordings or anything like that? You're gonna have to put those in some other pleading. But at this point, Miss Weaver is gonna prepare the record. She does that, and like I said earlier, the record should be ready soon. And you all, as a defense group, will have the opportunity to take a look at that particular ex parte transcript that was done in chambers, less anything that is totally that the court considers to be privileged. And I'm going to let you do that before you examine Mr. Copeland. So you'll have everything that you.
But what counts as privilege, and what can you guys take out, and why not just give the full recorded? Hey, listen, man. I feel like this judge should be in prison. I feel like he should. Yo, bro, he's as dirty as they come, bro. Any judge that needs an emotional service dog, man, shouldn't be presiding over anything. Y'all let me know in the comment section, what do you guys think about this, man? And if you're still watching, click on this video somewhere on my screen to find out why this LA Mexican gangster just sent a strong warning to No Jumper for doing this. Click on this video right here to find out what I'm talking about. Out of here, folks.